Good afternoon. It is Tuesday, March the 26th, and we are ready to start the Judiciary Committee hearings. And I'd like to start, if at all possible, and I am Delegate Charlotte Crutchfield, and if all possible, I'd like to start out with Senator Carter's bill, which is number 2, SB2. And Senator Carter, are you ready? Do you have all of your witnesses?
So my witnesses were in the scanner when I came in.
Okay, so we can. Okay, because we can pass and then.
No, I would, Madam Chair and members of the committee.
You're ready.
First of all, I am so fortunate and thankful to tell you that I have so many bills that came over this year and bills in every committee. And so I greatly appreciate the opportunity to go first. So I'm going to just give a brief opening, and hopefully by that time, the Strader family will be in. They were literally walking in with me, and then they got held up at the scanner.
Okay.
So basically and briefly, you all, most of you at this point have heard of the Michaela Strader Act. Shortly after the Juvenile Reform Act went into effect, that very same month, Michaela Strader, a 15-year-old, was killed at the hands of a 9-year-old child. And so media swirled around the issue of the fact that that 9-year-old, under our new law, was not subject to any type of prosecution, no juvenile court jurisdiction. In the course of that, I saw the Strader family and their grief, their complaint that nothing would, not only that nothing would happen to this 9-year-old, but even if anything did happen, it was discretionary and they would never have a way of knowing, since it's all secret, confidential, because the child was 9. And so their point was valid, that because when they first met with me, I said to them, hey, this child can actually go into a sins process. And the response was accurate. Well, they could, but they won't. It's not mandated. And so that's where we work together to come up with this law, to make it mandatory that the child would go into a sins process should that child be under the age of 10 and not subject to the juvenile court jurisdiction. And with that, I'm going to be brief, because really we are here to hear from the family. This bill is about the very reason that we are here serving our constituents, when we can actually pass a law that actually is meaningful in the lives of the people that we represent. And so that is why this bill is so important to me, and I'm certain to all of you. Thank you very much.
Thank you. And go ahead.
Peace, everybody. My name is Boloon. And I served as Nakayla's big cousin. And I spoke last time when we were here at the House speaking on the bigger bill. I won't belabor my point then. What I'll focus on at this portion is being a citizen of Maryland. Over the past 2 years, I do believe that through this fight, we've learned a lot as citizens. But it's a hard thing to actually maneuver, trying to figure out how to testify, how to find out how to get in contact with Baltimore police, etc. What we've been able to see over the past 2 years is that this bill has been vetted. It's been passed by the Senate. It's been looked through. We've sat with the state's attorney's office, both actual renditions of the state's attorney's office. We've sat with Baltimore Police Department. We've sat with other police departments up until this point. What we've been able to find is that sins is not the issue. The problem is how educated have people been on sins, and how much information have they had on sins up until that point. So some people have collaborated with us, some have not. But the people who have sat down with us, brought other people to the table and broke down those silos and brought the family into those conversations, we found more successes, which is why we believe that we are here today. So I'll end on, hopefully you all will take a look at the bill, look at some of the other departments who have spoken about sins, but more importantly, understand that there are families like us who are missing the services, the little boy who are missing the services that'll be taken care of with this mandating of this bill.
Okay, thank you. Go ahead.
My name is Donya McCray. I'm the great aunt, the guardian. I've raised Kayla since she was a little girl. I've been, the last 2 years, a lot of things has changed in my life. since this happened, I've become even more involved with the kids in the community and all over. I've been out advocating for the youth and the kids, doing different things in the community to try to make it better. And I believe a lot of people ask me, why do I still fight? Because she's not here. Because I feel like she's not here, but I can save another kid by changing some things and doing different things, doing it better. She's not here, but we can make it better for the next kid so they won't have to go through what we do. So these last 2 years have been, her birthday just passed on March the 15th. She was 17. And again, I went out in the community and I gave back to the kids and honor her. And I just pray that we can make a change for the kids coming as far as this law, and making sure that a lot of these kids that I'm meeting get some of the service that they haven't gotten, change it and make it better for them because they are our future.
Thank you very much. Senator Carter, I only have down Mr. Parks and Ms. McCray as witnesses. That's it? Okay, because I see someone else.
My dad, we actually just got here. He would have liked to have said something, but he had to park. So unfortunately, no, he probably won't be able to speak. Sorry.
Okay.
Madam Chair, we aren't used to being called this quickly. The family actually told me they were prepared to sit for 5 or 6 hours, which has been the custom. So with that, I think that we'll just open to any questions if we have, if there are.
If I may really quickly, if you don't mind, something I talk to my dad about fairly often. My dad is a doctor. He works in the public health field. My aunt down at the end, she's worked for DJS. So a lot of these, he's actually walking in right now. I see the bald head shining. So the point that I know that he's going to make is that in the public health field that I work in as well, we believe that it's just a matter of time as a young man like him will end up in the system if he's not properly serviced. They did a wonderful job of doing the proper reporting of what has happened to people who grow up in these environments, not just people who look like me, but people who grow up in such environments with not the proper support. And that's what we want to see this kid and other kids get. And it's our firm belief that if we shelter them this way and not blame the other departments for being shorthanded, but find the proper people and get them the proper help and not continue to regurgitate that issue, is where we feel that we can collaborate together as citizens of Maryland to make this a better and safer place. He can probably say it himself if y'all will allow it though.
Well, we're going to just keep it to what we have down.
Yes.
So does the committee have any questions for any of our, okay, so Delegate Kaufman?
Yes, Senator Carter, this question is for you. I wondered if you had any reaction, if you've had a chance to read DJS's letter of information, if you had any reaction to it, because it was hard to follow what they were getting at, but it seems that they were sort of suggesting they were already doing what you proposed. But at any rate, I just wanted to give you a chance to react and potentially rebut the letter, and I wanted to extend my condolences to the family. So thank you, Madam Chair.
Thank you, Delegate Kaufman. So I have the letter of information before me, and my response is the same as it was last year, which is that the purpose of this bill is to mandate that in these very severe and extreme and tragic cases, there is a cens petition filed and not leave it up to discretion. Absolutely, the department is capable of doing this now. The question is, are they doing it and is it mandated? So this is simply to turn discretion into mandate. Thank you.
All right, and Delegate Taylor, I believe you have a question.
Yes, thank you, Madam Chair. Thank you, Senator, and my condolences to the family as well. Just for clarification, the language in this bill was part of House Bill 814 at one point, right? Why was it important for you to have this be a standalone bill?
Yes.
Oh, and why?
I think the family could maybe speak to it more. Well, because one, we passed it in the Senate last year as a standalone bill. And the way that this bill was created is exactly, in my opinion, it illustrates the primary reason that we are here. When constituents come to you with a real life problem or situation, and you can propose a real life policy solution to fix it. And so I feel strongly that we should have passed this last year. And I did not feel the family appreciated having their standalone bill, the Michaela Strada Memorial Act, swept into a larger bill, some of which they did not agree. So to have their bill put into a bill there were actually provisions that they took issue with was just to find the better word I can't do. It felt a little dismissive.
Okay, are there any other questions by the committee? Let's see. Oh, okay, Delegate.
Thank you, Madam Chair, and thank you, Senator, for the bill. And Delegate Taylor kind of touched on where I was trying to go. I was trying to figure out what was different from this bill versus what is proposed in HB 814. Is there any additional, let me back up. Since you have been working on this and the family has been on the ground trying to work with communities and children, is there anything else that you think in this process that this bill has right now that should have in it that is not? Does that make sense? I wanted to just, because you're in it, you're trying to talk to the kids. I know your great aunt, the guardian, was saying you're seeing different things. Is there anything that we're missing that's in the SINS process or not in the SINS process that this bill could address?
I'll let them answer.
Sure.
If I can really quickly, and Dad, please. We work with kids, right? A lot of those kids, we've been able to bring this up to their parents, and they are astonished that they have the option, right? I have 9 to 15-year-olds that work with me at Pennsylvania Avenue Market. The second they continue to see that they can steal cars online, the first thing they did was pull it up on YouTube to how to do it. 3 of them been locked up since, right? But I already have these kids. I already have them working. If I now have an understanding of SINS. If I could go and have it mandatory, I can be assured of the process that these kids are going to get. Before, it's to the discretion of whoever. The parent can say no. They can say their parent is fine. So now that I know that there's a tool, I know how to maneuver and go to the police. I know that I now can start the process. I don't have to have a parent to do it. As a community member, if I'm concerned, I've been educated to be able to get involved and then align myself. I didn't have that power before.
Do you have a follow-up question?
And I guess the last part is that I want to make sure that just as you said, now you understand that you have that ability to do so, that the programs that are happening in these communities, that they're really going to be the ones that will be able to send the kids to. You know, it's one thing to talk about it in legislation and say, you know, we got this, we have that, but the ones that are working in the community, I want to make sure that there's a true assessment that they are working and to get those kids to that process. So, you know, I certainly grateful for what you're doing and how you're, you know, staying steadfast and getting this bill passed, but I want to make sure they're getting to the right places. And I know that's not a question, but just to thank you for the bill.
And isn't that so?
I think we all agree with you, Delegate. That's a real concern, and that's why, to the credit of this body and to some work of this committee, well, depending on what the final outcome is, but you know, the $12 million that we're infusing into the DJS for the programs and services, I think that the commission that's going to conduct that oversight is critically important to make sure that we use these community connected on the ground programs that are evidence-based to work and not some lofty, exotic, out of touch program that may not really know and understand our children.
And I wanted to also just comment that HB 814 was amended to actually exclude this issue from the bill. So it is no longer there. So this is in fact a separate bill that totally deals with the issue. Are there any other questions from the committee? Okay, seeing none, I believe that ends our bill hearing on SB 2.
Thank you,
so
Madam Chair and
much.
Committee.
Thank you.
And I think we will have next SB 17, and that is Senator West. If you'll come on up to the mic. All right, Senator West.
Thank you,
ahead.
Delegate Crutchfield. Nice to see you.
Same here.
It's nice to be back. I feel like it's old home week around here. This is Senate Bill 17, and Delegate Embry had the cross file House Bill 667. You've therefore heard this. I'll just remind you what this bill is about. This is under current Maryland law, a person who serially abuses multiple animals, dogs, cats, horses, etc., in violation of the laws prohibiting animal cruelty is only charged once, regardless of how many animals have been abused. So a person keeping multiple dogs, for example, in unspeakably cruel confinement, covered with welts, starving to death, can only be convicted of a single crime of animal abuse. This bill allows for each instance of abuse and each animal abuse to be the basis of separate charges. It states that each animal harmed in a violation of the crimes relating to animals subtitle of the criminal law article will be a separate offense, and that a conviction under subtitle 6 will not merge with a conviction for any other crime based on an act establishing the violation. In this way, Senate Bill 17 will help to better prosecute individuals involved in the most depraved forms of animal abuse. So there was no opposition, articulate opposition in the Senate. I think we had some filed opposition from individuals, but they didn't come and testify, and they didn't testify remotely either. Otherwise, everybody's in favor of this bill. We passed the bill unanimously on the Senate floor. There is a Senate third reader version of this bill, which adopts some amendments. And now we have a new amendment that's been put together by the animal advocates, which is available, I think, to this committee. It's been provided to the committee. I just looked at the differences between the new amendment and the third reader copy of the bill. There needs to be one further amendment to eliminate a one sentence from the third reader version of the bill to make the bill complete. And we'll make sure you get that. With that, I would hope that you would give a favorable report to the third reader Senate version of this bill as passed by the Senate, as well as the new amendment, and then the new amendment, which we'll provide to the committee, hopefully within the next day or so. And then if you would also, it'd be great if you could confirm Delegate Embry's House bill to conform to the Senate bill as amended and pass both of them. It'd be terrific. And with that, I'll take questions. I see Delegate.
All right. Senator West, could you just one more time go over the two new amendments?
Yes,
so that
okay.
It's clear. Thank you.
So on the Senate floor, there was a question about whether or not this bill would cover domestic animals and farm animals as distinct from animals that are hunted or fished. So an amendment on the Senate floor said this section only applies to a domestic or farm animal. That was regarded as not by the advocates as not being specific enough. So the new amendment, which has been provided to this committee as of March 22nd, should have deleted that sentence, but didn't. That's what the sentence that needs now to be deleted. And instead provides that the bill does not apply to any hunting or fishing activity. So it would thereby include all farm animals and all domestic animals and exclude animals which are being hunted, or legally fished in the waters of the state. That's what the two amendments do.
Thank you so much, Senator West. And are there any questions? I see Delegate Aragon.
Thank you. Yeah, so that was a question I had. So it says the final language in here says this section only applies to domestic or farm animals. Okay.
Right. So that will come out.
So you'll remove
for one thing, there was no definition in the code. Even though the term domestic animal was used repeatedly, there's no definition of it. I guess it's regarded as being self-evident, and there's no definition of farm animal.
Okay.
So those two, that line is going to come out. No longer will there be any reference to domestic animals or farm animals.
Okay. So it will apply to farm animals though.
It will.
Okay.
It will only not apply to animals which are hunted or fished.
Okay. So I'm just trying to think of a scenario where somebody has a flock of 200 chickens.
Right. They're farm animals.
Right. So
if they abuse it's hard to imagine somebody doing that. But if someone were to abuse 200 chickens.
Right. What are the actual crimes that are like?
Well, those are in the fiscal note, and there are lots of them.
Okay.
If you go to the fiscal note, you'll see a page and a half of crimes.
Okay.
Each with different penalty amounts.
Yeah. So, I mean, some of these are
Cockfights, for example.
3 years in prison,
dog
felonies.
fighting.
Yeah. Aggravated cruelty.
Yeah.
Those are obviously really disturbing.
Very disturbing. Right.
Having a dangerous dog. So, okay.
So in this,
Unauthorized
now, if you
surgery.
have a whole group of dogs, you're training for dog fighting,
Right.
and they're all slashed up in a mess.
Yeah, so
You can
let's,
be convicted for each dog rather than just once for all the dogs.
okay, and most, okay, I think I understand. So most of these wouldn't apply to farm. I just worry, like, if you get into a situation where you're really policing farming,
Right.
I mean,
Well, there is
I'm not taking my chicken to the vet, okay? I'm not doing that. You know what I mean? So, I just want to make sure that we're being reasonable with our restrictions on people, and some of this stuff, I mean, $1,000 fine for a flock of 200 birds is a problem. That's, a huge problem. From a
flock of 200 birds.
Right, so
Okay.
if I, for
Well, if you're
example.
legally hunting the birds, you have a license and you're shooting the geese.
No,
and the
your own,
ducks.
like your own birds, your own chickens or whatever. I mean,
Oh, chickens. You're talking
yeah,
chickens again.
yeah, not illegal hunting. I just want to make sure that none of the crimes in here are actually going to apply to, regular farming practices. And there's just a lot of stuff in here. And some of it is, 90 days in jail. 90 times 200 is a lot of days in jail. Do you know what I mean?
Yeah.
That's kind of where I'm
I
going.
understand what you're saying. There is a default. The 10604 is just abuse or neglect of an animal. And
Okay,
that's the 90 days imprisonment or $1,000 fine.
right.
Then all the rest of these crimes are more specific situations.
Yeah, it's individual types of animals.
Right,
It looks like
exactly.
mostly.
Yeah.
So, yeah, I don't know, maybe there's some language tightening that we could do. I just don't want to trap our farmers in a situation where maybe they gave an animal, I don't know, let's say they improperly administered an antibiotic and it caused a loss of their flock or something like that. And,
Right.
is that abuse and neglect? Who can say? Somebody could probably make the case. Are they looking at 90 days for every bird they killed?
Yeah, I would have a hard time as a state's attorney. Jennifer Bevan Dangle is here.
She will
If-
not allow me to have people answer
Okay,
questions.
so maybe you could
she's a
have a
good chair.
conversation with Ms. Bevan Dangle offline.
Yeah, we'll
And
chat
she could
offline.
satisfy your concerns?
Yeah, thank you. I appreciate it.
Sure.
Are there any other questions from the committee? Oh, Delegate Conaway.
Thank you, Chair. Thank you, Senator.
Delegate Conway, nice to see you again.
Good to see
It's
you.
been a couple of
I
years.
hope you still feel the same way about me a little bit later. So
I'm sure I will.
in reference to offense 10-623, leaving a dog outside and unattended by use of restraints, like someone might leave the dog outside on a leash.
Right.
So if they have two dogs, that penalty would stack.
Two dogs that what?
If they had two dogs that they left outside on a leash, the penalty was stacked. They would get 180 days.
I think that's right. We passed a bill last year. I was the sponsor in the Senate of the bill that it says you can't leave dogs outside unattended for over a half hour if in the glaring sun, if it's over 90 degrees and there's no shade, or in the middle of the winter, if it's below freezing,
Right.
again, more than a half hour. So if you had two dogs and left them outside, you could be arrested twice, once
Right.
for each
But if it's a
dog.
nice spring day and it's
No
beautiful-
problem.
Well, that's not what this says, what I'm looking at. But what about declawing cats?
What's that?
The declawing cats, 10-625.1.
Yeah, we
Civil offense.
passed a bill last year, I think, on declawing of cats. And prohibiting that. So this amendment does refer to declawing of cats. But we didn't ask them to do that. That was part of the legislative services thing. When they do bills, they rearrange wording.
Sure.
So already it says that the sections don't apply to 3, an activity that may cause unavoidable physical pain due to an animal, including food processing, pest elimination, animal training, and hunting. And I think that includes the declawing of cats. So that's now just been put into different wording,
Okay.
but we're not changing the law in that regard.
All right. Thank you very much, Senator. Have a good day.
Thank you. Now, you see, I still regard you as a good friend.
Thank you. Are there any other questions from the committee? Seeing none, I believe that's the end of the hearing on SB 17.
Thank you very much, Delegate Crutchfield. Appreciate being here.
Thank you. And Senator Sindor, would you please come on up for SB 111?
Yes, indeed. Thank you very much, Senator Sidnoff, Senate Bill 111, and I think after hearing the last two bills, mine will be the quickest because you all have voted unanimously. I think it was 20-0 for House Bill 458, for which Senate Bill 111 is the cross file. I do come before you asking for, I believe the way that you all passed it was slightly different than what we did. There was an amendment that you all had put on page, it would be on page 2, line 13 of my legislation. The court had asked that the phrase "upon notice that an electronic or paper filing includes identifying information of a minor victim, comma, then notwithstanding any other law will be included." And I spoke with the House sponsor of this legislation. I'm fine with that additional language. And with that, I just ask for a favorable report.
Thank you very much, Senator. Are there any questions from the committee? Okay. All
Got that
right,
right?
Delegate, go ahead.
I just wanted to say to the Senator, this is a really good bill, isn't it?
I believe it is. You're helping young victims not to be victimized by the system. So, thank you all very much.
All right, I don't see any other questions. Thank you. All right, and if you don't mind coming on up, Mr. Chair, Senator Smith.
Yes.
Happy to hear about SB 744.
Excellent. Well, good afternoon, everyone. Madam Chair, members of the committee. You're familiar with the bill that came out of the House. I know that was subject to a lot of discussion and debate. And so what I'll do with your indulgence is just kind of explain the differences and walk through, and then I'll open up and take questions as needed. So I'll just walk through sequentially through the bill, and I'll take questions at the end. In the Senate bill, we had delinquency jurisdiction for gun crimes and for third-degree sex offense, whereas the House, you all kept in aggravated animal cruelty, third-degree sex offense, and motor vehicle theft. You created a diversionary program for the first offense, but then the rest of the offenses would remain in delinquency jurisdiction. The gun crimes that were enumerated were wear, carry, use of a handgun in a crime, possession of regulated firearm, transfer of regulated firearm, straw purchases, transfer of stolen regulated firearm, participation in straw purchase, obliteration of a serial number, possession of short barreled rifle or shotgun, and ghost guns. The House version did not have the straw purchases. So I think those are the only gun offenses that were not in the House version. We also had created a two-day inquiry, a two-day intake inquiry, where DJS denies a request from law enforcement to detain a child. So when that happens, there were a couple of decision points. For the DJS intake officer, you can do an informal adjudication, you can do a petition for delinquency or a sins petition at that point, or you could just close out the case. So what we did was, I think that the House intent here and the Senate intent here were the same, which is to reduce that time, where there's a difference between what the DJS wants to do and what law enforcement wants to do, just to reduce that time to 2 days, where in current statute, it's 15 days. So I think we both were pretty much in sync on that piece. We have slight differences on the mandatory reports for arrests. I know there's some discussion centered around, what level of contact. I'm sorry. I can give you the page numbers, but they're different on the House and the Senate version. So I could give you the Senate version, but for the House version, I could do side by side if you wanted.
So Senator, does it make sense just for you to go through the way you're doing it and then connect it later with the
absolutely.
pages? Okay.
Yep, and then we can cross-reference page numbers from the House and Senate version if you like. There's still some, I know, further discussion going on of what level of interaction for contact would have to exist for a paper trail to be generated. So are we talking about kids throwing rocks at a empty warehouse? Are we talking about kind of a stop and an investigatory stop and some further interaction? So I know that's a level of I know that's a subject of further discussion. For failure to attend court-ordered treatment, the Senate bill allows child to be sentenced to a new term of probation if they miss twice without good cause. That just essentially extends the length of probation. So there are no other consequences other than the length of probation being extended. I think your bill, the House product defines good cause for the purposes of extending that probation. For the 3-year outlayers for the, I think this is for the DJS 3-year plan. I think we have an effective date of October 1st, 2024. You all had pushed out the effective date to January 1st, 2025. Some of the other items that are in the Senate bill, but that are not in the House bill, we require the forwarding to the state's attorney of all cases which a child fails to complete an informal adjustment. DJS will tell us, and I think it's told this committee as well, that this is kind of their common practice anyway. This just codifies that. There's also language clarifying that DJS can begin an informal adjustment while the state's attorneys review a case. So while it's being reviewed, DJS can, what they do is sometimes there's programming or, treatment options that can happen in that pocket before the state's attorneys decide to go to delinquency route. So it just clarifies that they can do that. That's kind of common practice anyway. It requires a report to DJS whenever the law enforcement officer could arrest, but does not arrest. So I think there's some improvement to be done there. We carve out second-degree assault from the misdemeanor offenses that are eligible for pre-hearing detention. I don't think that exists. That carve-out exists in the House version. Requiring notice to the court when a child on probation has 4 or more unexcused absences from a court-ordered treatment. We require a pamphlet to be provided to victims of crime to include information of how to file that SINS petition. I think that's a pretty friendly addition, which adds for more information. Anyone can file these SINS petitions anyway. This just gives more clear information for a victim of violent crime. And then there are some differences in the commission. We have a representative from MSDE. We have 2 representatives from the consortium on coordinated community supports. That consortium is born out of the blueprint. And you all are probably aware that it just recently awarded $111 million to mental health and substance abuse supports to students that are in our public school system. So we put 2 members of the consortium on there. The chair is appointed by the governor in our version, and then the commission is required to report annually on December 1st in our version, in the Senate version. And with that, Madam Chair, those are the major differences. I'd say as they are entered into the respective chambers, we're 85, 89% there. I know that there are a few points of discussion that will be happening in the hours and the days ahead, but we're pretty close with a few points of departure. But with that, Madam Chair, I'll rest and take questions.
Thank you very much, Senator Smith. Are there any questions from the committee? Yes, Delegate Conaway.
Thank you, Chair. Thank you, Senator, for coming in. Can you speak about page 3, line 21F, theft of a motor vehicle under 7-105?
Is that the Senate version or the House version?
The Senate, I'm looking at the Senate version.
And I'm sorry, what page again?
Page 3.
Page 3. Do this Senate version, let me see. I have the House version in front of me here. Page 3, go ahead.
Line 21F.
Thank you. Line 21, theft of a motor vehicle under the criminal. Yeah, so what we did was we created, so that's no longer under delinquency jurisdiction. We created a mandatory SINS petition process for that. Speaking openly, I mean, I think that's, I'm a proponent of that provision. The SINS process still does involve some level, there's the state's attorneys on one side, there'll be a judge, and then there will be, the counsel, either a public defender or private counsel for the youth involved. And that is a better process for, I think, service delivery and does not involve supervised supervision.
Thank you very much.
Okay, Delegate Pastor.
The addition, please, the 2 members from the consortium, because it's more of an umbrella with a number of different agencies. So how will those 2 members be selected, and what do you see as their contribution to moving the purpose of the commission forward.
Yeah, so you all as a committee held some really essential and informative hearings over the interim. And I think that was instructive to your work moving forward. We also did something similar at the beginning of session. And one of the briefings that we locked in on was chronic absenteeism and truancy and the nexus between, if at all, the criminal justice system, but then also some of the contributing factors for justice involved youth and school. And so having folks from this consortium who are steeped in all elements of service delivery for students who are in the public school system come and then lend their perspective to this group, I think would be instructive because they're experts in understanding the contributing factors to chronic absenteeism, truancy, and the nexus between that and the justice system for our youth. So we thought that they would be valuable contributors.
May I just a little tiny one. Thank you. The agencies or the organizations that are under the consortium, under each county, are all a little different. They tend to go with emotional and et cetera, as social and some emotional. So in selecting, would it be the executive director of the consortium? Who will pick those two? I'm just concerned because that commission is exceedingly important to me because it is the umbrella, but for this bill and for what's to happen. So I just want to make sure that the people who are on there are not just bodies and names, but people who really can address what our children are going to need. So who will make that selection so that we can ensure that they're going to do and really be on what you just described? Because what you described is critical.
No, I thank you for the question. So the bill isn't as prescriptive as to what the direct qualifications of that member would be from the consortium. So I hear you there. And I do not believe that we have, I think the deference would be to the governor, but I'll have to double check. I don't think that the bill speaks to that. It's silent on who has the authority to pick those two people from the consortium. Potentially the chair of the consortium, but we can be more prescriptive of that. And if that needs to be changed, then I'm sure we're open. I understand your concerns, and I saw the twitch. But I share your concerns as well. And I think there are valid points. Yeah.
All right, Delegate Tolles.
Thank you, Madam Chair. I have a, hello, Mr. Chair, good to see you.
Hey, good to see you. Thanks.
I have a question in terms of the effective date. You changed it to October, you said back to October?
We had it initially as October 1st, 2024, which is the general effective date of the
Correct, any bill.
Default. I think that you all tell me. I mean,
So I'm sorry, my question, did you,
Sure.
I'm sorry, you did change it back to October 1st?
It was always
Right.
October 1st.
Okay, I
Yeah.
thought we changed it to December. I'm saying the version that came to you was December, correct? Oh, no, the version that came to you was January.
The version that
January
the
1st,
House version is
2025.
January 1st, 2025.
Right.
Yeah.
And you changed it back to,
You could characterize it as, we never had it as January. Our version always had it as October.
okay,
Yeah.
right. So the rationale as to why you changed it, why you want October versus what we
Sure.
just changed.
I think you all spoke to, and I'm not as familiar with the base, you tell me, but you pushed back the effective date of the commission or of the legislation because you wanted the commission to get started working to lay the groundwork for the substantive
That's
points of the
correct.
bill.
That's
We
correct.
did not have that discussion. We said, look, let's get started now. Let's start the implementation now. That is a point of departure between the two bills that
Right.
I think we could come to compromise on. The point
Okay.
of having the commission start up to lay the groundwork for the implementation of the legislation is well taken. I do think that January of 2025 is a little far, but I'm certain we can come to a meeting of the minds on that point. But I think that's where you all were coming from, and we just didn't have those concerns.
Okay, thank you.
Thank you.
But I don't want to speak for this committee, but yeah.
Delegate Phillips.
Thank you, Madam Chair. And Mr. Chair, when we talk about the departure of the House approach versus the Senate approach, you mentioned sins, and in our bill for the little children, we were referring them to some type of diversion program. When we began this process, personally, I was pushing language that was very similar to the Senate bill as it relates to driving those young people towards the sins process. During the process, we began discussing this idea of diversion. Why have you thought that sins would be the better approach to the diversionary approach? That's one question. And then the second question really has to do with some of the issues that arose while we were discussing 814, which was the capacity of the sins process. So if you could just address those two issues.
Sure, absolutely. Thank you very much for the question. So one thing that's frustrating for, I think all of us probably agree that the sins process is probably, if it worked like it was drafted in statute, is the preference over delinquency jurisdiction. I think almost all of us could probably agree with that, because it's not supervised housing or incarcerated. There's no element of that, but it's a faster way for service delivery. Also, one of the more salient points that I thought the most important thing that the public defenders brought up in particular in our hearing was that when you're dealing with this age population of 10 to 11 and 12, that the levels of incompetency to stand trial pre-JJRA was 2/3. So just based on the age, 2/3 of that population is just going to be incompetent to stand trial, which means they get set off on a different path, which is not copacetic for treatment and rehabilitation. And it takes a long time. And that part of the system needs significant reform. And I think that's probably a conversation for next session and the session after that and the session after that. But so that was a major concern when you have too many things in delinquency. Also, when you looked at the pre-JJRA numbers for handgun related offenses, they were fairly small. This entire population is very small. It's less than 10% of the violent crime in Maryland. But the handgun related crimes, the people that are actually getting involved in were small. And so I'm kind of speaking out loud here, just being completely honest with you. And so I felt like for the car auto theft, that was a significantly higher number. And so if you have a sins process that isn't functioning like it should, and it's different across all 24 jurisdictions, but you want to force that issue and you want to make it work, I think the approach should be not to abandon it. It should be to make that system work. The auto theft, which is a larger population, is the best way to do that. The handguns, which are smaller, much smaller sliver, and because handguns are inherently, in my mind, inherently dangerous and maybe warrants different style of treatment, we thought that was the best way to do it, to kind of slide the auto thefts out of delinquency jurisdiction, force sins to actually become sins in real life and make that process work, while keeping handguns subject to delinquency jurisdictions. Discretion's interwoven between all of this. So doesn't mean you're going to be under supervised housing, but you could be for handgun related offenses. So we just thought that was a better approach to the problem. And so that's why in your version, you have the first time diversion, but the second time is under delinquency jurisdiction. So we just thought that was the better approach to it. This is really just the beginning of this conversation, because I think the sins process really, we as a body should focus on making that work as it is written in statute. That would be the best thing. We're far from it, though.
Thank you very much, Senator. Okay, and Delegate Roberson.
Yeah, thank you, Madam Chair. Good to see you, Mr. Chair. Just because I want to be clear about the differences as far as especially what's included and what's excluded. So when you walk through, let's see, you have section B, C, D, E, and F. So you removed, and I think Delegate Conway raised this, you removed the theft of a motor vehicle.
Yes.
Am I correct? And then for going back up, crime involving animals, you removed that portion.
Correct.
As well. And then for public safety, you changed that to 5-133, 134, 136, 138, and so on and so forth. What do those include?
So
overall?
the bills are identical in that regard, except for which is 54141. So that's 5-141, which is straw purchases. The House bill does not include straw purchases. We do.
Okay, thank you. And then just to be clear, thank you. Also for the inquiry for intake officer, you gave them 2 days to refer it to the state's attorneys.
Well, to make a decision. So I think actually the House bill and the Senate bill are the same here. It's just drafted a little different. So I think we're pretty much, I'm looking to council too to maybe confirm that, but I think that it's pretty close, where the intent was the same there, but so I don't think there's a departure there on policy, just the drafting.
Okay, got it. And now all cases though will be referred to the state's attorney for them to make a decision.
No,
on
so
those for
we
reports?
have all felonies go to the state's attorneys. But this is different. This is a different process.
Okay.
This is so when DJS denies a request from law enforcement to detain a child, and I talked about there are a couple different options there. There can be an informal decision, like there could be a petition for delinquency or a petition for sins, or they could just close it out. But when there's that contention, DJS doesn't want to detain, but law enforcement says yes. They have 2 days to make that next step decision. And right now it's 15 days in statute.
And then just to be clear, so state's attorneys are still getting all these reports though
For
and just
felonies.
for records. Okay.
So a different process, but yes, for felonies under the Senate bill, they're getting all of those reports. At which point they could make a decision as to whether to petition or what. I mean, or just, but they get eyes on for all felonies under the Senate.
Right, versus the ones that are referred directly to sins, state's attorney's office do not receive those reports.
Depending on what the offense is, yes.
Okay, thank you.
Okay, Delegate Williams. And I will come back to you, Delegate Tolles, okay?
Thank you, Madam Chair. A quick question. I guess I'm just trying to understand the rationale for removing the provision around crimes involving animals. And the reason I say that is just typically when we see children engaging in, whether it's torture of animals and things like that, that's usually a symptom of something else, whether it's sex abuse or something along those lines. And so I wanted to just
No,
touch bases on that.
we felt that was just, thank you very much for the question. We felt that was just an element that we could remove because it was so rare, exceedingly rare. I think we found just only a few instances of that happening. But to your point, I did do some research and I saw a couple of DOJ reports and other reports that basically substantiate exactly what you just said. And so I think certainly willing to entertain putting it back in because I think some of the attributes that they're afforded to future bad behavior are definitely present there. So yeah, we're definitely open to that. And I think I appreciate you bringing that up.
Delegate Rammer.
Thank you, Madam Chair. Thanks for being here today. So one particular part of this problem that's bothered me since we started looking at this was the data issue. So for southeastern Baltimore County, the juvenile crime problems, it's more of a 10-year problem. These issues that we're seeing everywhere, they've been going on in my district for 9-10 years at least. The problem happens when you talk to people and they say, no, the revolving door, the child going into the system, coming out of the system the same week, multiple crimes in the same month. It's not happening. Actually, one of the delegates from Montgomery County on the floor said this problem is completely overblown. We're passing this legislation unnecessarily. In Baltimore County, juvenile crime, when we talked with law enforcement, juvenile crime is up over 100% from 2021 to 2023. Can you tell me why the Senate has not put in any information to provide the public accurate tracking of what the actual juvenile offenses that the jurisdictions are seeing as opposed to what the Department of Juvenile Service is giving us?
So meaning like disaggregated from 24 jurisdictions as opposed to one centralized kind of DJS reliant?
Generally, yes, but more broadly, Department of Juvenile Services, they say, quote, juvenile crimes down, it's down 60%, which is not the case. And I think we've seen in your jurisdiction, the numbers coming from the jurisdictions show us a significantly different story. The crime is actually up everywhere. The juvenile crime is up everywhere. So disaggregated, yes.
So we had, again, I talked about the good work that you all did over the summer with your hearings. We did briefings, informational briefings, not bill hearings kind of, but another bill hearing that we had, a briefing we had rather, it was on violent crime trends in Maryland and across the United States. And I highly recommend folks check that out. It's actually it was some of the best briefings we received. So I do want to say that I think it's, not to be insensitive to this, I think it's clear that violent crime trends across the nation and in Maryland are down as a broad trend. But there are significant spikes in certain areas of crime. And juvenile crime is less than 10% of that violent crime, although there are significant spikes in juvenile crime in certain areas. And that's why I think both houses or both chambers have chosen to focus in on where we've seen those spikes, which is auto theft and carjackings. It does already a crime of violence, but carjackings, auto thefts, and firearms related offenses. And so that's why the legislation focuses on those things. But I always say that have this thing called, you got to focus on trend lines, not necessarily just the headlines. The headlines are important because they're telling you what people are, reading and thinking about, but the trend lines are what you need to do to make informed policy in the long run. And so I do want to be sensitive to the perception and the real impact of violent crime and youth and juvenile violent crime. But I think the numbers are universally reported as what I've just said, that the general trends are down. You wouldn't know that by reading, the newspaper or the news. Second, I'll just say this real quick, and I'm talking too long, but you have to understand the comprehensive approach that we've all taken on this. We put $111 million into for mental health supports and substance abuse supports. We have put $43 million into the offices of the Governor's Office of Children. Put $24 million into DJS to develop programming aimed at auto theft and handgun related offenses. We've created a correctional ombudsman, but also the JJMU. You have a bill in here that creates a really independent unit that's has subpoena power to really exercise that check over the Department of Juvenile Services. So you've got more transparency, more accountability, and more investment. So we've taken a really comprehensive approach this session, and I think it's important to not lose sight of that.
But I didn't mention violent crime. I mentioned juvenile crime.
Yeah.
And you get the trend line from the data. So how do you get the data if you don't, how do you get the trend line if you don't have the data? And that's my point. The data that we're continuously referred to shows juvenile crime is down when in fact it's up significantly. Retail theft from 2021 and 2023 in Baltimore County is up 74%. And that you could just gloss over that without the data. So I continue to question the fact that we're even drawing accurate trend lines.
Well, hey, look, I think we all want more data is better for more informed decision making, and to the extent that we don't have to rely on just one entity to produce that, then I'm all for it. So yeah, 100%. You got a bill. I mean, Senator Sidnor just up here, he had a bill for I know my friend Mr. Schellenberg is behind me, but for the state's attorneys to have prosecutorial decisions and charging decisions and all those things, all that data collected as well. I mean, I think more data is better. So yeah.
All right, Delegate Simpson.
Chair. Hi.
Hey.
Good to see you.
Good to see you.
So my question, I'm going to piggyback on Delegate Williams, is that given the age of these children, of course, my background being more in the child welfare aspect, given how young they are, and then of course married myself a juvenile justice individual, so is that they don't do that great of a job of really doing those assessments. And when we're talking about the violent crime, and we're talking about rape, and we're talking about murder, and I know you took out the animal cruelty, hopefully we put that back in. There's nothing in the bill that really talks about the people who are the experts, which is social services, doing an assessment on these kids for twofold. One is these kids are exhibiting and basically throwing up the flag saying something terrible is happening to them, whether or not we're making sure they're not continuing in that type of environment. And I know juvenile services is much more looking at, you know, the behavior of the child. But the other thing is there's the assessment. They're the best at assessing, are there other children in the home that are subject to the same type of behavior? Would you be in agreement to add something to this bill requiring that because of the age of these children, that we would have an investigation by social services for their safety as well as, you know, the home environment?
Look, I don't know if the proper vehicle is this bill, but I think that's a great suggestion. I mean, I think the more you can identify all of the attributes of the behavior and the more you can provide the wraparound supports and services, that's great. I mean, I think you've seen models across the state that flood resources into kind of someone that's been involved in the justice system. And I think that's what I think, you know, essentially it's a number, you know, some of the programs that DJS is in the nascent stages of developing, like the Thrive program, are aimed at doing something just like that.
Now of having it in this bill is because you've described all the red flags.
Yeah.
And then that's where that would come in, is for them to get that assessment.
I think it's a great idea.
Thank you.
Delegate Tolles.
Thank you, Madam Chair. I just wanted to piggyback off my initial question, which I know why we did it. And I wanted to explain that further because there seems to be some questions as to whether that was clear or not. And the reason why we moved that date to January 1 is to give, as somewhat to what you alluded to give, you know, the commission additional time to be able to understand the new law, get it ready in place, and be able to also let you know, the public know that the changes that are coming forth. And why do you think, well, not, I don't mean to say it like that, but you know what I mean? Like, tell me your reasoning or the committee's reasoning as to why this can be done within a 2-month period. Because given that January 1 time is, you know, stretching it out a bit to give them more time, why do you think if you take it back down, take it back, put it up, however you want to do it, it's different than what we sent it over to you? Is that, why do you think October 1 would be sufficient of time for them to be able to get the commission and everything underway before the implementation date of December?
First, I would say that what the discussions you had and the rationale behind your choice to push it back is valid, and we understand that. We didn't have that discussion in committee or on the floor because, you know, we do big things in the legislature all the time. We pass big legislation all the time, and the effective date is always October 1st. And so to me is, why wait, why delay? Let's get started. It's going to take a long time to implement and start up anyway. So it was just kind of, it wasn't even a subject of debate in our chamber, but I take what you did is valid. I mean, I understand the concerns.
Delegate Phillips.
Thank you, Madam Chair. I was trying to go back to the House bill. One of the things that I think was different were some of the requirements for when a law enforcement officer engages with a child in a situation where that child might be charged with a crime. My sense is that you all go a little bit further to Delegate Grammer's point in ensuring that we collect certain pieces of information. Did you all think through that? Because I think for those persons who don't get actually arrested, when we're thinking about crime and collecting data, my sense it is important to collect information at that point in time. And I'm not sure that we went as far as perhaps we could have with 814. So do you want to comment on that?
Sure. We wanted to Delegate Grammer's point and to your point, we wanted the most information possible. A lot of law enforcement agencies would tell you that it's kind of common practice for them to issue a report when there's an arrest. But what about those other points of contact that don't, result in an arrest but are significant? I think where I think we're not as far apart as it may seem initially, but I think the considerations have to be how laborious it is for law enforcement to issue paperwork on Did I walk by, I saw kids throwing rocks at an abandoned building? Did I talk to them? Did I say, hey, get out of here? Does that necessitate a report? Does waving to someone necessitate a report? Does going through a public park or a zoo and you see people and you talk to them, does that necessitate a report? I think where's the line is hard to discern. And so I think as we come together, we're gonna have to figure out what the right level of touch is to necessitate paperwork. Because you understand, I mean, it could be very laborious on one side. On the other side, you better have adequate paperwork if you bring someone in to an intake officer. So I think we're not as far apart as it may seem, but those are discussions that we're gonna have to have in the next couple of days.
I think, well, I think it's important that we figure out, and that we may have to be prescriptive.
Yeah.
Right? Because at some point, to Delegate Grammer's point, to many of us, we don't know reality or perception.
That's right.
And with all of the incoming that I think we're receiving, it seems to me that we need to figure out reality from perception as best as we possibly can. How flexible are our Senate colleagues on this issue of going one route versus for car theft and another route for guns, when we've kind of said we're putting them in the same boat, particularly for those 12 and under, and we're putting them in the diversion, or let's say maybe we go to SINs. How strongly does the Senate feel about the way you've addressed your issue?
For the auto theft and the SINs, fairly strong. For the first level diversion and then still remaining in delinquency jurisdiction, I think there's a conversation to be had there. But the SINs, we've thought that out and had a pretty lengthy discussion on the SINs process for auto theft. So on that one, it'd be a more difficult lift.
But what about guns? Because you've taken them and put them immediately in
delinquency jurisdiction.
Delinquency.
And you all have one diversion and then still in delinquency jurisdiction. So I think there's discussion to be had there. That's a point of, I think, further discussion. Yeah,
Thank you.
There's some daylight there, but yeah.
Delegate Pasteur.
Thank you, Madam Chair. Mr. Chair, I really want to go back to the commission. I'm
Yes.
just stuck there.
Okay.
And I'm stuck there because everything that Delegate Grammer Phillips, everyone has said really does come back to that. First of all, we would agree, I think, that what's in that first part as it is now in terms of penalties, what we do, how we work with our young people. But the commission, and I've gone over it and over it, isn't the purpose of the commission, or is the purpose, what is the purpose of the commission as you see it and the Senate?
I think, look, they're going to meet 6 times a year, report back to the governor and to you, me, and everyone else in this room. And they're going to evaluate the juvenile justice system from kind of soup to nuts. They're going to evaluate and identify gaps in programming and service delivery and make recommendations to improve. And they will have a level of they're going to be responsible for providing a level of transparency and accountability for the juvenile justice system. So yeah, it's a very important commission. Yep.
It is, and I thank you for that. And it also says that it is going to make recommendations about programs.
Yep.
It's going to look at the programs that exist and things that are, and it uses the word promising programs and practices. So it is ongoing based on what I see in the bill.
Yep.
To make sure and to hold everyone accountable for taking care of our children.
That's right.
Not just once they're in the second system, as I call it, but to keep them from being in that system. Would you agree?
I'm going to use that second system analogy in the future, but I would agree. Yes.
So I guess I'm going back to Delegate Toll's question and your answer, her question 2 times and your answer twice, that there was not really a lot of conversation about the commission. You looked at the first part. but you said the first time I asked my question, these aren't your words, so correct me if necessary, but in essence, that you were sort of open to taking a look at the date issue, because the point of the date was to give the commission an opportunity. This is a lot to ask of people who in July, and we said, we hope that all of these people are really going to be selected before July so that they start processing, as Miss Nancy used to say in Romper Room, put on their thinking caps. Okay, you don't know what I'm talking about. All righty, so raise your hand if you do. Okay, so that by the time they come together on July 1, they are ready to start working, because our children don't have any more time, right? Would you agree with that?
I'd agree.
So every month, every day, every moment that they have to make sure, and you said we don't really send, we want to make sure SENS is doing what it's supposed to do, having the programs. Every moment that they have to be engaged in this while life is still happening and children are still doing what they do is important. So, okay, here's the question. I'm digging. Can we count on you to go back to the Senate and have this full-throated conversation about just how important it is for the commission to do its work, so that when we start, we're starting to make things better, not just in a situation because we always start on October 1.
No, I say so. No, yes, yes is the answer.
No, yes.
I'm willing to have that full-throated discussion, and I think, look, like I said, I think there's a place for us to come together on this, because we do big things all the time. They're always, we always implement them on October 1st. The blueprint for what to do is the statute itself. And I think that the commission will be all important in ensuring that the statute is successfully implemented. And I think there's discussion to be had there. And so the answer is yes, I will go back and we will have that full-throated discussion on the issue.
To keep them out of the
second system. There you go.
Thank you.
Picked up some new stuff for the lexicon, full-throated and the second system. I got
It's
it.
amazing what you'll learn over here in
Yeah.
Judiciary.
Oh.
So for our
I
last
can't
question-
comment on that because they may not let me across the street again.
Well, I learned a lot over in JPR too.
There you go.
So,
There you go.
There we go. Okay, Delegate Cardin for the last question.
Thank you, Madam Chair. Thank you, Mr. Chairman, for coming. I like the bill, and I'm trying to figure out how we're going to reconcile them and make something really good come out of it. So that's great. Getting back to Delegate Phillips and Delegate Grammer's questions, just wanted to highlight my feeling that the data, we need to make sure that we have data. And the reason I say it, I've said this in the previous hearing, when we had a briefing, state's attorneys came up and briefed us, and then the Office of Public Defender came up and briefed us, and the Department of Juvenile Services came up and briefed us.
Yeah.
And it was as if we were living in not three different like countries, but three different universes. Like the data that we were getting was, and I'm assuming that they were all the same facts, but they were compiled differently, or there wasn't a full amount of the facts coming through. According to 8-14.1 that we're going to be amending here, it sounds like if the child's taken into custody, then that information is going to be captured somewhere for a report in D1. If there's a written complaint, if the child is referred to at-risk youth prevention and diversion, there's going to be a report filed, and Part 3, a written report to the Department of Juvenile Services indicating that no further action was taken, it sounds like, it's going to all, I'm still not 100% sure that how we make sure that the information comes to some central location that can give us a disinterested understanding of the effectiveness of our policies, so that we can then take that and make the changes we need to, because we know it's not going to be perfect. And if this isn't doing it, we need the House and the Senate need to sit down and make sure we're getting all that information.
First, I'll say I share the sentiment, because the most maddening part of this entire process was exactly what you described at the beginning, where you had testimony from DJS, the public defenders and state's attorneys, and it seemed like there were no concentric circles here. They were so far apart. It felt like you were living in different universes, and that was maddening because all you want to do is find a disinterested evaluation of information so you can make a better decision. I think this is not going to be the panacea for that. Okay, this is a start. It's going to create more of a paper trail, and I think that's going to help us, but this is not the silver bullet. This is the start of that. I don't know. I don't have that answer for you, but I share your concerns, and I think that I hope that the commission and the JJMU that's now separate, independent, armed with subpoena power will be able to go in and not only make sure DJS is doing a great job, but also do some confirming of data. So we'll see how that works out, but I think that's a further discussion. I certainly share your frustration.
Thank you.
Mr. Chair, thanks for joining us over here.
Thank you very much.
And I appreciate the dialogue. That ends the testimony for Senate Bill 744.
Thank you for getting me off the hook here. I appreciate that. I'll probably see you next week, but yeah, short bill though. See you later.
I know, right? Okay, so we're going to go ahead and start testimony. I don't see Senator McCray in here. Is someone from his office? Right. I just want to make sure no one from his office is here. Okay, let's go ahead and go to Secretary Lopez. You have two bills. So we're going to start with Senate Bill 270, and then we'll hear Senate Bill 708. Mr. Secretary, whenever you're ready.
Wonderful.
Thank you.
Madam Chair, members of the committee, I'm Rafael Lopez, and I serve as the Secretary of the Department of Human Services. We are driven by 12 core values of the administration, and one of them is being data-driven and heart-led, reminding us to rely on data and lived experiences to drive our decision-making. The data tells us that despite their important role, many adult public guardianship review boards face challenges due to vacancies. Yes, I should probably say it again. We are talking about SB 270. I saw a few questions. So SB 270 of the two bills that Madam Chair called, and this is regarding our adult public guardianship review boards. So currently, 23 out of the 24 jurisdictions have board vacancies. The adult public guardianship review boards in each jurisdiction must regularly evaluate the health and welfare of the individuals under guardianship and make recommendations to the court regarding the continuation, modification, or termination of guardianship. SB 270 proposes to streamline membership requirements for the Adult Public Guardianship Review Board and to reduce the number of vacancies across the state. In 1984, these review boards were created to review all guardianship cases held by public agencies, including local departments of social services and the area agencies on aging. And for context, all of the local departments of social services are part of the State Department of Human Services. Area agencies on aging serve as the guardians of the person for adults age 65 and older. Local departments of social services serve as guardians for adults aged 18 to 64 and continue serving as guardians for our customers once they reach the age of 65 to ensure continuity of care. Specifically, SB 270 would change the number of members on a review board from 11 to 8 members while maintaining multidisciplinary expertise. It will allow a psychiatric nurse practitioner or a professional with experience in prescribing or oversight of mental health medications to serve in place of a psychiatrist. Many jurisdictions struggle to find psychiatrists who can devote the time to serve on a guardianship review board. The change would address this challenge while ensuring each board across the state has the requisite knowledge and expertise about prescription medications. Multidisciplinary review boards must be fully recruited and retained to ensure unbiased reviews that protect individuals' rights and provide adequate care and attention. A full guardianship review board is essential to protecting the 1,700 Marylanders under public guardianship today. Guardianship review boards review each case twice a year, conducting approximately 3,400 reviews each and every year. We respectfully urge your favorable report of SB 270, and I'm happy to take any of your questions.
I see no questions. Mr. Secretary, you can proceed with Senate Bill 708. That ends the
Wonderful.
testimony for Senate Bill 270.
Okay.
So Senate Bill 708, members.
So 708 for our colleagues is the bill related to kinship care. So once again, in the context of using data to drive data and heart-led decisions, we want to bring to your attention a very important movement in where we're leading the state of Maryland together in terms of creating a kin-first culture in this state. Senate Bill 708 establishes a research-informed framework for our kin-first approach to out-of-home placements that will improve outcomes for children and youth experiencing foster care. And as of March 25th of 2024, there are 3,758 children that care in custody of the state of Maryland. We are moving urgently forward with a kin-first approach. For context, kin-first policies promote a holistic framework of child well-being. Research nationally continues to demonstrate that foster care placements with kin do a variety of things, including minimizing trauma, increasing the likelihood children will remain with siblings, increasing permanency by providing stability with fewer placement disruptions. It improves children's behavioral and mental health outcomes, reduces the risk that children in out-of-home care will be trafficked, and maintains family, community, and cultural ties that function as protective factors for children. Ongoing child development research continues to reveal that the psychology of childhood bonding and attachment are far more expansive than previously understood. Research is demonstrating what we know intuitively. The whole psychosocial environment matters to a child's psychological health. In short, children don't just bond with parents and caregivers, they also bond with communities and culture. Currently, only 23% of children in foster care in Maryland are placed with kin. Senate Bill 708 would prioritize important childhood bonds, including those found by blood or by marriage, when considering the best interests of children who require an out-of-home placement. In 2023, the federal government issued a new licensing rule authorizing a different set of standards for licensing kinship caregivers and encouraging state agencies to adopt a broad definition of relative and of kin. Senate Bill 708 would clarify the definition of kinship caregiver by including relations through blood, marriage, tribal law or custom, or cultural custom or practice. It would also provide a preference for placement with kin, which evidence demonstrates result in far better outcomes for children. We urge your favorable report of SB 708. Thank you for your time and are happy to answer any of your questions.
Thank you, Mr. Secretary. I have a question that I was
Certainly.
thinking about asking on the House bill.
Sure.
I didn't, so I'm going to ask it now.
Sure.
So the definition of kinship parent is removed, but the term remains on page 3. Can you tell me what a kinship parent is?
Sure. So if you could point me to the exact page, I can look at the exact language that you're looking at so I can make sure I'm
Sure.
speaking to the same
Okay,
thing, Madam Chair.
So we start on page 3.
3, under 3.
And we have taken out number 3, the definition of a kinship parent.
Okay.
Okay, but at 2, the kinship caregiver includes 1, a kinship parent. So I wanted to make sure that a kinship parent is somehow defined,
Certainly.
reference, or,
Certainly,
yeah.
absolutely. Happy to clarify that question, Madam Chair. So as proposed, we specifically use the terminology kinship caregiver. And part of that is because research, again, and best practices informs us nationally that there are many people who can actually care for and love the child. So for example, I might have an auntie who's related by marriage. For example, in the Latino community, my own community, we have, when one is baptized, we have padrinos and madrinas, which are godparents in the Catholic Church, for example, that may not be related by blood, but are related through custom or tradition. So kinship caregiver in this context provides a couple of contexts. Specifically on line in number 2, kinship caregiver includes a kinship parent. It also includes an individual who's related to the child through blood or marriage, adoption, tribal law or custom, or cultural custom or practice. Those are the kinds of examples I just tried to give. Similarly, it's an individual who is unrelated to the child, but has a strong familial or other significant bond with the child, or is a person identified by the child's parent. So for example, again, in the context of making this very practical, the person who I would consider my father figure is a person who's not related to me by blood or by marriage, but is more a father to me than I ever had biologically. So the way in which we're trying to expand the definition here in Maryland is to be as expansive and as inclusive as possible so that children can grow up with people by whom they are loved.
Thank you. So I appreciate that clarification. I guess what I'm confused about is the definition of kinship parent has been removed altogether. But we do reference a kinship parent. And so my question is it still a person who is related by blood or marriage within 5 degrees of consanguinity or affinity under the civil law rule to a child who is in the care? Is that still part of the definition? Or are we considering a kinship parent to merely be a parent? Or is kinship parent further defined or in another place of the article?
It's actually, it's the way we approached this was to integrate it into a variety of places within the law itself.
Okay. Okay, I get it. Okay, thank you very much. Are there any other questions? Seeing none, that concludes the testimony for House Bill 708, Senate Bill 708. I got to get used to that.
It's okay.
Thank you very much, Mr.
Thank you.
Secretary.
Have a wonderful afternoon.
And Senator Muse, thank you so much for coming back to us.
Absolutely.
I appreciate you coming back. So Senate Bill 174, testimony with Senator Muse for Senate Bill 174. And whenever you are ready, we are ready. Thank you.
Thank you very much, Madam Vice Chair and members of the committee. It's always a pleasure to come here. I think about the times I was here. I believe when I was here, though, we were only a 2-room building. We had a committee in 1940 something. No, you ought to have come a long way. Trust me, you probably even have telephones. You're my buddy, man. For the record, I'm C. Anthony Muse. I'm here in support of Senate Bill 174. It was drafted to minimize the negative systemic impacts of the child enforcement agency's automated license suspension mechanism and ensure that this enforcement tool is only used in appropriate cases. It is a cross-file of HB 311 sponsored by the esteemed Delegate Karen Simpson. She's worked extremely hard on this legislation. My understanding is my committee chair and your committee chair, they've gotten together to figure out some ways to move the bills forward. And I will submit to their wisdom so that we can move something forward, because this is a very important bill, and it really will affect a number of lives. So because I know you have this bill here and you've already had the hearing and you've had long hearings all day, I hope that this is the hearing that is just the least wordy of anyone that you've had today. Having said that, I'll stop and urge a favorable report and look forward to both chairmen working together with my friend and working it out, and co-chair as well. Yes, co-chair. Yes. All right.
Great. Thank you, Senator. Are there any questions? Seeing none, that concludes the testimony for Senate Bill 174. Thank you very much.
You were always so kind and light on me. Thank you all. Have a good time for as we get.
All righty. So we have Senate Bill 139. Is anyone here? Oh, great. For Senator Watson. And if you be so kind as to, you've changed, Senator Watson.
I've gotten younger.
So if you'd be so kind to introduce yourself, we will get started with your hearing. Thank you.
Certainly. Thank you, Madam Chair. My name is Clay Jackson, Chief of Staff to Senator Ron Watson on behalf of Senate Bill 139. Senate Bill 139 provides an exception to the driver's license suspension statute for child support obligors making less than 250% of the federal poverty level, which translates to roughly $36,700. The Office of the Attorney General supports this bill, as well as advocates and the Department of Human Services. This bill is also cross-filed, although not technically joined. It's cross-filed with House Bill 813, Delegate Tolles. Though not technically adjoined, they are materially the same. And similar to Senator Muse's bill, the JPR chair and this chair have come to an agreement on this bill as well as the House Bill 813 to move either one or both of these bills. And I'm happy to answer any questions.
Great, thank you very much. I see no questions. So you did a great job. Thank you very much. We'll tell the senator.
Oh, thank you.
Tell him that we miss him.
I will.
So that concludes the testimony for Senate Bill 139. Thank you very much. Members, we're going to take a quick recess while we wait on our last hearing for the day. So we'll take about a 5 minute recess. Don't leave your seats, just stand up and stretch. Well, you can do that. All right. Okay, members, we're back in session. We're going to go ahead and start with Senator McCray, and this begins the hearing for Senate Bill 652. Senator McCray, whenever you're ready.
Thank you, Madam Chair, members of the committee. For the record, Corey McCray, Senator for the 45th Legislative District. I come to you in reference to Senate Bill 652. I did try my best to get a cross file. He was missing in action with DLS, getting it over. But what this does is it just kind of creates a system that I was able to build with the previous Secretary of DJS and making sure that we all have that process that goes on. Madam Chair, Vice Chair, if I can just go into a little bit of why this took place. So anytime there was a group of juveniles that were shot in my district, typically I meet with my police commanders and I meet with Department of Public Safety. And anytime there was a group that was shot, side, I would reach out to Sam offline and say, hey, are any of these folks under your purview? If they were under the secretary at that time, Sam Abed's purview, I would ask him understand what was the wraparound, what after action did you do? How long did it take you to put your arms around them and make sure that identifying what services was necessary? I look to do that with the same with the incoming secretary. We had a bit of a bump in the road. The bump has been fixed at this time. They are supportive of this bill, but making sure that I don't have to do that offline. That information is accessible to all of us, no matter what legislative district that you're in. They report it out to us, and making sure that we have transparency around what is the after action that takes place after there is a juvenile that's under their purview that has some type of non-fatal shooting or fatal shooting. I think that it makes sure that even if something doesn't go the way it's supposed to go, that we can then take a look and say, what could we have done better to make sure that we adjust and move forward? And I'm gonna stop right there. And like I said, I wish I did have a crossfire, Madam Chair, but unfortunately I was late to the dance.
Oh, that's all right. That's all right. Delegate Erican.
I do kind of want to know who you wanted to put on that cross file though, so we can tease them as well. So my only question is there any, did you get any pushback from anybody?
No, the agency came out and said that they have the information. The information will be able to be put forward. So there was zero opposition.
Okay, and it moved unanimously?
Unanimously in the Senate.
Sometimes that's the most dangerous words in the English language, but I think in this case, it might be a good thing. All right, thank you.
Yes, ma'am.
Delegate Sample Hughes.
Thank you, Madam Chair, and thank you, Senator, for the bill. I love your proactive approach that you were already out and doing this and getting this information. But if you could just walk me through how that works. So is there a site that we would go to secure what the information is?
Yep.
Because I know you were doing yours orally, just trying to keep up what was going on. So what does that look like for us?
So Department of Public Safety does this for adults currently. And what happens is we get a report every year that's sent to the respective committees, and we can then see, and sometimes there are audit of it and things of that nature. And that was where I got the concept from, because this was already done for adults. Why weren't we just utilizing the same type of language and doing it for juveniles, being respective of laws that we have to protect juveniles from that standpoint, the names and things of that nature, but also being able to work through. So we'll come to the respective committees.
Oh, you're saying, I guess I'm looking at it from perspective. If a shooting occurs in your district and you want to know what has occurred in the process, you're waiting for a report to come out, not just like information that you could receive with like within 2 weeks that's up on a system and you can try to figure out where the.
So my system that I take an approach, I get all of my public safety folks, and Baltimore City just has some different dynamics than some other parts of the district. So I meet with my commanders every 2 weeks. And every 2 weeks, they will walk me through every single homicide and every single non-fatal shooting. And then I would ask them questions. Are they on parole or probation? What ages are they? Was this person apprehended? How long did it take them to apprehend? So what is our like the detail, like how are we responding to that specific neighborhood now that we know it might be a heightened. So I'm looking for certain characteristics or certain understandings that say this is what's driving crime from that standpoint, and understanding what these public safety, parole or probation is on the same calls. So we have the folks from Secretary Scruggs' shop, and I've been doing this for about 3 or 4 years, and I've watched violence go down, because there's a certain level of accountability that's happening when you know that somebody's going to question what you're doing or what actions you're taking.
Okay, so it's like a two-prong approach.
Yes, ma'am.
You're having your one-on-one sit down, and then there's a report to which this bill is what we're speaking of.
Exactly.
Okay, and last thing I'll say, there was an initiative that we had, and it's changed its name over the administrations, but it was originally Hotspots, and then it was the C-Safe initiative. But what it geared toward, and trying to get my community back in that same process, was to make sure parole and probation is at the table, the code inspectors are at the table. All of those agencies were together, and we met weekly. And that was to, one entity would say, this is what I'm seeing, this is what I'm hearing, and then we all collectively work together. So it's kind of the same concept, but it's very on the grounds and interactive. Okay.
Yeah. I just think from an accountability standpoint, our job ain't to micromanage folks, but from an oversight standpoint, we just need to make sure that when we see something that looks out of place, there's probably something there, and just ask the basic question. And if the basic question is immediately answered, then probably they're doing what they're supposed to. But if it's not, I think we have a responsibility to dig deeper. Yes, ma'am. There go my guy.
Yeah, I mean, this would have been a great crossfire for somebody.
That's what I'm talking about.
All right, thank you so much, Senator.
Y'all have a
Appreciate
blessed day and thank you again.
too. You too. So that concludes the testimony and the hearing for Senate Bill 652. That concludes our bill hearings for the day. Thank you, members.